Hello and welcome back to our channel. Happy to have you here again if you're a returning subscriber, and if you're new here, then welcome to SoLegal. In today's video, we will be taking a dive into human rights law, which is a core law course for law students across the world, Nigeria inclusive. We'll be introducing human rights law in Nigeria in today's video. So whether you're a human rights student or whether you're a law student offering human rights, or you are a human rights advocate, or just a curious person looking to see what human rights law involves, then you find this video useful. So let's start with the basics. What are rights? In a grammatical sense, if you're looking at the literal meaning of rights, it's essentially a valid claim to something that you are entitled to. So it could be land, an object, a privilege to do something or to say something. That's what the grammatical meaning of rights would involve. But in legal parlance, the word right has a much stronger connotation. It refers to the legal capacity that a person or even a group of persons have to do something, or to sort of control the actions of others, or even state actions as well. Now, it's important for us to distinguish between a right and a privilege. A privilege is a form of permission or license or a concession that is given to a person either by another person or by a state figure. It isn't an entitlement, it is a privilege. Whereas a right is enforceable, as opposed to a privilege which can be withdrawn at any time. As the jurist Salmon says, a right is an interest, the respect of which is a duty, and the disregard of which is a wrong. So the enforceability goes with rights, and where rights are derogated from, where they are abused, it becomes a wrong. So what makes a right human rights? We just generalized, we just defined or gave a description of what rights are. So when does a right become human rights? Well, the concept of human rights involves fundamental entitlements. It speaks to entitlement that every individual has simply by virtue of their being human. So because I am human, I am entitled to those rights. They are inherent to myself. Because you are human, you have those inherent entitlements attributed to yourself as well. Human rights are not privileges, they're not gifts, they're not concessions that the government just gives, which they can withhold or withdraw at any time. They are enforceable preconditions to any civilized existence. And we already said that human rights are entitlements that a person, an individual has by virtue of their being human. The Nigerian Criminal Code defines a human as a person that has proceeded from the womb of a mother. So upon birth of a person in the context of Nigeria, that person already has human rights. The person is already entitled to certain rights that are termed human rights. Well, the idea of human rights is rooted in natural law rather than positive law, because by virtue of being humans, we're entitled to those rights. And we see this captured in the preamble to the American Declaration of Independence of 1777, where the preamble states that it is a self-evident principle that the Creator has endowed man with certain inalienable rights, including life, liberty, and the pursuit of happiness. So these rights and similar rights were described to have been endowed on humans by the Creator, and they are inalienable. You cannot take it away from them as humans. In the Nigerian context, the courts have agreed with this with this position that human rights flow from natural law. And there's the case of Ransom Kuti and Attorney General of the Federation, where Justice Kayode Esho stated that qualifying the right as human removes it from the ambit of positive law. So it is the creator, not the government, that is the donor of these rights. In the same way, the case of Asemota and Yesufu, the court emphasized that fundamental rights correspond to jus natural, so it is an inalienable right that is endowed by nature. Now, because these rights are basic, they are intrinsic, they cannot easily be waived, and you do not lose them just because you did not exercise them. So far, we've talked about rights, we've talked about human rights. What then is the difference between human rights and fundamental human rights? Human rights, as has been repeatedly said, are rights that are intrinsic to humans. Once a person is born, once a person is human, that person has those rights. Fundamental human rights takes it a step further by being enshrined in statutes. So fundamental human rights have the backing of legal enforcement. They've been enshrined into supreme law of the land in the case of Nigerian law, in the constitution. And so those rights can be enforced, will be enforced in case of a breach or likely breach. Now let's move down to the features of human rights. There are about 6 core features that you want to know about human rights. And the first one is that they're universal. So they apply to everyone, regardless of your geographical location or origin, regardless of the political systems that operate where you live or where you are from. You have those rights. The right to freedom from torture, it applies to everyone. Just because they are humans, regardless of where they are, they're entitled to being free from torture. The second feature that you should know is that they are inherent and they are inalienable. So inherent, intrinsic, they come with the human, and inalienable, you cannot take it away from the human. Human rights cannot be stripped from you. You cannot strip them away from yourself or give away your human rights. So an example would be a person attempting to sell himself or herself into slavery. It doesn't take away the person's right to liberty. You cannot separate the person from his right to liberty. So an action like that wouldn't be possible or wouldn't be right within the ambit of human rights. Another feature is that human rights are interdependent and interconnected. So what this means is that the fulfillment of one human right usually depends on the fulfillment of another right. So you have the right to vote, which is a political right. Your expression of this right or your enforcement of this right is closely linked to your freedom of expression, because it's a form of expressing your political views. So they go together. And that's how most rights work. A person has a right to life, and in protecting the right to life, his right to freedom from torture is also enforced. So interconnection, interdependence. A fourth feature of human rights is that they are indivisible. So all human rights have equal status. This feature is a bit related to the interconnectedness of human rights. You can't separate these rights, neither can you prioritize them and say we are going to ensure that you have your civil rights and you have your social rights, but we're taking away your political rights. It doesn't work that way. Human rights are a cohesive package. Feature number 5 to note about human rights is that they are non-discriminatory. So human rights applies to everyone, regardless of their race, regardless of their gender, their ethnicity, or even their religion or social status. Everybody gets to have the human rights because they are human. And number 6, human rights are enforceable. We touched this a bit before. These rights, more than privileges, more than mere wishes, they are backed by laws. They are backed by enforcement mechanisms that allow individuals to seek justice, to seek redress whenever their rights are infringed upon. So there are always remedies for the breach of human rights. While we have these 6 features in mind, it's also important for us to know that human rights are, even while enshrined in constitutions or in the law, they are usually not absolute. So there's usually the principle or the law guaranteeing the rights, and there are certain exceptions recognized by law under which those rights can be derogated from. We'll talk about this in future videos when we delve deeply into individual fundamental human rights that are guaranteed in the Nigerian Constitution. So another aspect of the introduction to human rights law in Nigeria that you need to note is the historical development of human rights. And this could be divided into 5 major periods, starting with the period of the Greek philosophers, featuring philosophers like Socrates, Plato, and Aristotle. Socrates, who is considered to be the first natural law philosopher, argued that laws of nature are primary, they are permanent, and they are inherently equal, whereas human laws created out of expediency, they come out of a need, and they usually create inequality. So for him, he stood by maintaining the rights that flowed from laws of nature. Plato, who was a student, championed individualism, and he posited that individualism is or was the centerpiece of rights. And Aristotle postulated that divine or natural law is always superior to the positive laws of man. So all 3 natural law philosophers maintained that natural laws were superior, better, and created equality in society. We are now moving on to the second period of human rights development, which is the natural law theorists era. And here we mostly have Catholic scholars for about the time period of 7 centuries. We had philosophers like St. Augustine and St. Thomas Aquinas. So for St. Augustine, as he wrote in his book, in his work, City of God, he was of the opinion that the divine city of natural law, that's the city of God, is much different from the city of man, which has or which is characterized by selfishness. And later on, St. Thomas Aquinas, he described human rights as the reason or the basis for liberation. This set of philosophers had a similar philosophy as the Greek philosophers, but this time they're maintaining that the divine laws, they are again superior to man-made laws, and flowing from natural law, all humans should have equal rights that were bestowed on them by God. The third period of the historical development of human rights is the Renaissance period, or the Age of Enlightenment, which was during the 17th century. And we had theorists like Thomas Hobbes, who wrote the Leviathan and described life as, you may already have heard it, nasty, brutish, and short. And we also have John Locke in this period, where he proposed the republican system of government in his work, Civil Government. It is also in this era that we have Baron de Montesquieu, who championed separation of powers. And his whole idea was that having that in place would prevent tyranny and infringement of human rights. And then there's Rousseau, who formalized the social contract. So before we proceed, a brief recap of the periods and the philosophers or theorists. There was the period of the Greek philosophers, where we had Socrates, Plato, and Aristotle. Then there is the natural law theorists, the period of the natural law theorists, where we had St. Augustine and St. Thomas Aquinas. And just now we talked about the Renaissance and the Age of Enlightenment, where we have Thomas Hobbes, John Locke, Baron de Montesquieu, and Rousseau. Now we're on to the fourth period of the development of human rights, and that would be the era of the great human rights documents. And this was the period where people realized that it wasn't just enough to have these ideals in philosophies, in oral philosophies, there had to be documentation. And so they began to codify these human rights principles. And it began with the Magna Carta of 1215. Then later on, there was the English Bill of Rights in the year 1689. And there was the American Declaration of Independence of 1776. And then sometime after, there was the French Declaration of the Rights of Man. The fifth and final historical phase of development of human rights is the internalization of human rights. Before the year 1945, however, the state treated its citizens was deemed to be personal. It was an internal or a domestic business. The international community did not bother itself with it. But after the First and Second World Wars and the resultant mass infringement of human rights, everything changed. There was the Treaty of Versailles in 1919, which laid early groundwork for internalization of human rights. And it sought to protect minorities, but the real work really came about with the United Nations Charter of 1945 and later on the Universal Declaration of Human Rights. So these documents had ensured that there was some form of international say or effect in the enforcement of human rights across states. In a subsequent video, we'll talk about the UDHR in detail as well as other international human rights treaties. Now, having seen how human rights has developed over the years, let's talk a bit about the generations, which are a sort of classification that were proposed by the French jurist Karel Vassac. And he proposed that human rights could be divided into distinct generations, 3 in number. And these generations are based on the French ideals of liberty, equality, and fraternity. So let's go over these 3 generations. The first generation is the civil and political rights. So these rights are referred to as blue rights, and they are negative in nature. They are negative in the sense that they prevent the state from interfering with those rights that the citizens have. So the citizens have these rights, and the nature of these rights are that the state is not allowed, well, except for the exceptions which we already said that usually accompanying human rights that are enshrined in constitutions. The state is generally not allowed to interfere with the rights to life of the citizens, expression of the citizens, fair hearing, and other civil and political rights. So, first generation rights, blue rights, negative in nature. They are negative rights. The second generation of human rights are economic, social, and cultural rights. So these rights are known as red rights. They are positive in nature. They're positive because they tell the states to do something. First generation rights, they tell the states do not do anything to interfere with these rights. But economic, social, and cultural rights tell the state to do something to confer an advantage onto the citizens. And examples are the right to healthcare, the right to housing, the right to education. So the state has to take steps to do things to confer these provisions on their citizens. That's why they have positive rights. However, one thing about this generation of rights is that they based on the available resources of each state. So they're associated with progressive realization. Not all states apply them the same way, and that's why we have different levels of economic development across countries, across states in the world. So each state would enforce these rights based on their available resources. And now we're on to the third generation of rights. So remember the first generation, which are blue rights and are negative in nature. They are civil and political rights, and their focus is liberty, rights, freedom, states do not interfere. The second generation rights, red rights, positive in nature, their economic, social, and cultural rights. Their focus is equality. People should have equal access to these things, to housing, to healthcare, to education. The focus is on equality. With third generation rights, these rights they are associated with peoples, a group of people. So their focus is they are solidarity or group rights, and they are green rights. These rights focus on fraternity, brotherhood, because they belong to a people as a group. They reflect interdependence within societies. And examples would be the right to development. A people, a group of people in a community has the right to develop itself using its material resources. A community or a group of people have the right to self-determination. They say they want to separate and be an independent people. They have that right. And there is also the right to shared common heritage. So these are rights that belong to a group of people. And as we will talk about much later, as we continue to develop human rights law in our videos, we will talk about how the African Charter on Human and People's Rights really expounds or really touches on third generation rights. So that's all for the three generations that Karel Vassar proposed. And there's a new generation of human rights that has been proposed because of emerging technology, and that's the fourth generation of human rights. So this would include rights relating to ICT and the cyberspace. Also inclusive are newer rights relating to sustainable development and the environment. And then a fifth generation has also been proposed, this one solely relating to good governance and democracy. So that's about it for the generations of human rights. As a recap, there are three generations proposed by Karel Vassar, the French jurist, the first, second, and third generations. However, with emerging technology and emerging environmental needs, as well as a need for accountability in government, two new generations have now been proposed, the fourth and the fifth. Now, what sources do we refer to in order to identify these human rights and even enforce them? We'll run through them. And these sources would include, of course, number one, the Constitution of the Federal Republic of Nigeria, 1999, as amended. And this is so important. It's the core source of human rights law in Nigeria because that is where the human rights are enshrined. In Chapter 4 of the Constitution, we find the fundamental human rights that are enforceable in Nigeria. And in Chapter 2, we find the economic, social, and cultural rights that, while recognized, are not exactly enforceable in the strict sense. In addition to the Constitution, there are international treaties that Nigeria is signatory to. There is the African Charter on Human and People's Rights, but because it has been ratified and domesticated, would refer to the African Charter on Human and People's Rights Ratification and Enforcement Act. And there's also the procedural rule for enforcing human rights, which is the Fundamental Rights Enforcement Procedural Rules of 2009. And again, other international treaties like the UN Charter, the UDHR, the ICCPR, ICSCR. Not to worry, we would go over these when we talk about the UDHR and other key international treaties in another video. But yes, this is basically all you need to know as base knowledge for human rights law in Nigeria. We've gone over the meaning, we've gone over key features, we've gone over the generations, and we also touched the historical development of human rights law. And that's pretty we just touched the sources as well. So that's pretty much all you have to know for ground knowledge in human rights law in Nigeria. We would continue the human rights law series in subsequent videos, with the next one touching the UDHR key international treaties. And that's how we bring it to an end for this video. Thank you for exploring Introduction to Human Rights Law in Nigeria with us. This is usually a 400 level course, or some universities have their students offer it in 200 level, some have their students do it in 300 level. It doesn't matter, but it's a core law course in the Nigerian legal system. So we're very happy to have gone over this today. If you have any questions concerning human rights law, leave it in the comment section and we'll address it in the comments. And we hope you stick around as we explore human rights law in Nigeria as well as other core law topics together. That said, thank you so much for watching. See you in our next video. Bye.